by Professor Dr. Wolfgang Weiß. He holds the chair for public law, EU law and international public law at the University of Administrative Sciences, Speyer, and his expertise ranges from public law and EU law over public international law with a special emphasis on German and European economic, constitutional and administrative law, as well as WTO and UN law. Thank you very much.
Thank you all for welcoming me here. Yes, we had 3 excellent presentations based on a well-elaborated paper, so I can keep my comments brief and short, but I will try to maybe raise some question marks to some of the hypotheses which were presented here, at least to challenge some of the basic premises. So with regards to the first paper, economic security becoming a topic or an objective of internal market. Yes, of course, the findings of your research was that this is the case, we see it. And that's actually not maybe the first one, the first example of foreign direct investment. I was wondering when I read the paper whether we do not have a forerunner in the defense procurement sector. Well, that is very peculiar. In Article 346 of the Treaty on Functioning of the European Union, you also have this carve-out that trading with ammunition and arms and weapons is, of course, an essential security interest, which is solely in the realm of the member states. And still, the European Union, in order to conceptualize and establish sometime a kind of common procurement market for defense goods, adopted a defense procurement directive in 2009 even. And of course we see even here that even though we have this carve out already there at that time, the Court of Justice, which later had to deal with this directive, said that this is not a complete carve out of European Union law, and it is still possible for the EU to somehow coordinate or even harmonize certain basic requirements of defense procurement within the member states. So we have some forerunner of this where we can see, okay, security, well, not only economic security, but even defense security, so the much more classical term, is part of our internal market law. Already then. So this discussion might be helpful for you as a comparative element in your paper and in your research. So even then, this procurement directive was based on what is now 114. At that time in 2009, it was still Article 95, I guess. So this competence of the EU was already used and exploited at that time to establish and enact this new EU legislative instrument, which we could say now. Some more comments on specific aspects. Of course, we have the challenge how to bring together these different screening mechanisms. If you have a foreign direct investment, the investor might fall under merger regulation, under foreign direct investment control, and also maybe under foreign subsidies review. So 3 review procedures at the same time. I don't think that we should try to harmonize the benchmarks in a coherent manner, because all these 3 instruments have a different focus. The one is on competition in the internal market, the other one is on subsidies, and foreign direct investment is about security issue and sensitive infrastructures. So, but what we need, and here I fully agree with you, at least that is a minimum requirement, that we need a procedural coordination, of course. That is necessary for the investors, maybe something like a one-stop shop so that they know who is responsible, because there are different DGs, of course, involved in scrutinizing then a foreign direct investment under these 3 different instruments. Let me now switch to Nachibula's analysis of the outbound investments and what is at stake there. Well, yes, of course. You coined this phrase, it's the stupid, no longer it's the economy stupid. Well, it's the politics. Yeah, well, both come together now in this area which we are discussing today and even yesterday, both come together because behind geoeconomics, of course, stands the attempt and the pursuit of states to use economic instruments. Tariffs, of course, is the most prevalent one in the US administration, to use such economic instruments for industrial policy purposes, but in the end it should serve the domestic economy, bring new labor force, bring reinvestment into domestic industries, so expand the export capacity of the US economy. So in the end, it's again about economy, but this time the states no longer trust into economic efficiency and the good work by the companies and the better productivity of their companies, but they trust in politics, accompanying economic logics. One of the criticisms you raised was the scope of application with regards to ratione materiae, which sectors should be covered. Yes, you're right. It does not fully, it does not reflect the scope which we have in the foreign direct investment regulation. What the Commission currently plans, but it's only a very professional consideration because we do not have a legal proposal, is less. Yes, so one could think whether this is this does justice to strategic autonomy. Well, I was thinking, should we really have a parallel scope of application? Might we not be careful to avoid overreach? Because the question which came into my mind is, do we really have a win if we restrain our EU companies too forcefully from going abroad? There are issues in technology where the EU is behind. For example, artificial intelligence. So as a EU company, if you want to contribute to cutting-edge research in that area, maybe it is necessary that you also invest your money abroad, in China, in the US. That, of course, brings problems, but that's why I say, well, outbound investment control must be carefully drafted. If we cut off our companies from the chance to take part in technological developments in other countries, that might not pay well, it might not pay off for the EU. So I'm a little bit more cautious to be overly restrictive. Can we really afford to limit investment in China or America and so constrain our business from doing research abroad, which might be more useful, maybe? Yeah, finally, a word about the international legal frame. When we look to foreign direct investment, then of course it's the GATS which might be affected because we have this mode 3 establishing a legal representative in another country which falls under mode 3, but of course well, MFN applies irrespective of the specific commitments which states entered into under the GATS. But still, the question is, of course, do we see a breach of MFN? Well, Islam, you said formally we do not, and I will comply with that finding. But the question is then, of course, and you raised that very succinctly, whether we still see some change. And of course, Other papers speak about the securitization of trade and trade relations, and really we can see, also learning from the discussions yesterday and today, that economic security has brought about a change in the way how we think about international relations, and that economic security brought about a new objective or a new tool or a new thinking, maybe a new thinking is a better word to frame it, a new thinking about how we can establish and shape trade relations. And so it's actually not the transformation of an MFN. In your chapter 4, your title was Transformation of MFN from Residual Exception to Organizing Logic. Well, it's not the MFN which has been transformed, but it's actually the way how to use security. It's no longer used as a exception which may be invoked very rarely. That was, of course, the understanding in past time. Now we find it everywhere, all over. It's now a shaping logic for international economic law, for international trade relations. And you're right that you say, well, that is somehow has turned into a security filter, a new lens under which states look at their trade relations. So I agree with your finding insofar, but would challenge you to reconceptualize it a little bit, as it's not really a transformation of MFM, I think. Probably we can say, well, if there is a breach of MFN, we can try to justify it under the security exception, which you also find in GATS, but that's the question, of course, could also be placed whether securitization becomes a logic within the aspect of likeness. Do we have like services if we have different feelings about security? So then, of course, we have a little bit of a transformation of the MFN as well, as we could consider issues of security also within applying MFN. And, well, that is, formally it's a way which the appellate body denied in the ECLC's case, only allowed that under the TPT agreement, not under the GATT, but the appellate body did not speak about GATS. But that is, of course, a way where we could say, okay, it affects also MFN and how we apply MFN if we, even on the basis of the wording of Article 2 GATS on MFN, we consider security issues. And then, of course, it would be relevant, where can we do this? Under likeness, maybe, under favorable treatment standards. Well, I have no idea about that, no fixed conclusion which I can present you. I only raise a question mark. Thank you so much.
Thank you very much. You have a first question?
Thank you very much for the very interesting panel. So I have a question, more of a additional comment for Isam, because I had this exact same thoughts like Professor Weiss, because in what you seem to argue, it's not really like a transformation of MFN, but rather a broad interpretation of the exception. Unless you want to include the security as an interpretation of like services or like services suppliers. And this actually led me to think about an argument that James Flett made in 2022 in a European Commission publication dedicated to 70 years of EU law. In that case, it was a bit different. It was with respect to MFN and in relationship to the CBAM, saying that considerations with respect to climate should be taken into consideration in the context of likeness, because it doesn't make sense to always have a violation and only subsequently trying to justify it under Article 20. So potentially for you, it would be useful to make a similar argument with respect to GATS, MFN, and the security exception, saying that maybe we shouldn't solve all the disputes at the level of the exception, but trying to resolve it at the likeness step. Of course, as Professor Weiss said, there is no currently jurisprudence that would support that. But you could at least try to make your own argument, like a similar argument as James said, the Deputy Director of EU Legal Service tried to make. Of course, this is more convenient for countries like the EU because then you avoid very strict conditions of the justification. Yeah, thank you.
All right, would you like to respond?
Thank you, Professor, and thank you for the remark again. The thing is, by transformation of MFN, what I mean, and as I explained it during the presentation, is that the shift is becoming from, the baseline shift is turning from the principle to the exception, where we are not starting from the principle of equality and non-discrimination and then invoking the exceptions. We're starting, it's like when you're solving an MCQ question or a problem and you do not know the answers, or you have a 50-50 chance. What you do is you go by elimination. So that's how I view the EU is approaching its obligation of MFN, is that the elimination process is happening through the security exceptions and the public order exceptions. So we're eliminating first, and whatever is left is treated as like situations, and to some extent. Because we're invoking, this transformation is happening by invoking the security exceptions first, by invoking the public order exceptions first, and then the principle of like situations is being...
Changing the order of analysis?
It's changing, this is inevitable. This is inevitable. So due to the economic security toolkit and due to the screening mechanisms and due to all the instruments, the shift is transforming in one way or another.
There was a change in Russian traffic in transit. They did consider first article 21.
Yes, but the thing is, proportionality is a key question, and good faith is another key question. So these are always ambiguous and vague exceptions. The thing with legal exceptions based on security and public order are left vague and broad, and it's what you said, that we can consider it as a broader interpretation of the exception rather than a transformation. But as this exception becomes broader and broader, it becomes the baseline, it becomes the threshold, because the key usually is for the baseline to be broad and the exceptions to be narrow, and not the other way around.
That's exactly what James says, and that's why he suggests to shift it to article, like to the MFN, not to become the exception that it is always seems violated and
Okay.
always be justified.
All right, any other questions? Yes.
Thank you. So I have a comment on Najib's presentation. Your criticism or skepticism towards the country neutrality of outbound investment screening really resonated with me, because you have the same phenomenon also with inbound investment screening. You don't have any lists of countries that are countries of concern, such as in the US. And I always thought that this is a little bit phony, because I think state regulators and the European Commission do know exactly which investments from which countries they want to screen thoroughly and which ones they are not really screening thoroughly. And I think this leads to a lack of information representation in the law, and I think it would be better from a sort of legal precision point of view to actually put the exact countries. It doesn't have to be a sort of a complete list, but at least the countries that are particularly problematic. I do understand also from a diplomatic point of view why you don't want to do that, but I think legally it's a problem. And also that brings me to the second point, that is kind of tied with that, and it relates at least a little bit to Oriana's presentation, because you still have the old test that was developed for investment screening that was developed by the European Court of Justice, and the genuine and serious threat to a fundamental risk of society test, and which is certainly going to be applicable to investment screening as it relates to investments within the European Union. I think the jury is still out on the question on whether it's also going to be applicable to investments that come from companies from outside the European Union. I think that's contested and not finally decided yet. But I think that's also kind of a test that was developed, especially in the golden shares jurisdiction by the European Court of Justice, some 30 years ago, is really applicable to different situations. And of course you can subsume the current geo-economic problems under this test, but I don't think it gives you a lot of guidance on how you're going to decide the case, and so I think the criterion is not very helpful. Thank you.
Thanks.
Maybe. Yeah.
Yes, thank you. Good point indeed raised. My argument to mention the countries by name is actually twofold or threefold. First of all, that is more not really a legal argument, but more a diplomatic argument, meaning it put pressure on these countries. So if you mention the United States or if you mention China specifically on EU level, then these countries hopefully will get the message without the consideration, because sometimes I have this feeling that the Russia or China have the idea that the European Union is divided, that the member states cannot agree. And we saw that actually also with the previous government in Hungary, right? So Hungary and Russia was using that quite well. So that's the first thing. You send a quite strong signal. And the second thing is it provides guidance to the member states. And thirdly, and I think it is will also lead to legal certainty, because investors in companies investing in those countries know a priori beforehand that this transaction can be reviewed. So they can take that into account in drafting all these contracts and all these issues. From a legal perspective, whether it's problematic, to be honest, I don't know. Maybe the only thing could be that you come into conflict with the MFN principle, but again, I'm not sure, because you are treating some of the countries differently. Again, that problem will not be big, because screening outbound investments does not fall under the current framework of the WTO. I mean, if it is about inbound screening, then I get the message that you cannot say we will focus on China. And I think that's also one of the reasons that in the current FDI screening regulation or in the new one, no specific countries are mentioned. Because then you will infringe market access and the non-discrimination, all these principles. With outbound investment screening, at least from an international economic law perspective, you have no limits, and no legal problems, therefore you can mention it. I think, and that will have some good benefits in my mind.
All right. Any other comments? Or
Thank you for your comments, also to the professor. I don't think I understood correctly your point. Is like a criticism that you have, like, because you mentioned the Xella case, the proportionality golden shares, like there is a lot of stuff. So I just, in order to reply, is there more like in how we should use proportionality test still, or if it's?
No, it was more a general point, I would say, and it was more related really to the extension of the point I made to Najib's case, the point of legal precision, right? So on the one hand, legal certainty, we're not mentioning what countries we really want to do the investments from, and then secondly, we use the old dogmatic category of genuine and serious threat to a fundamental risk of society test developed by the European Court of Justice for a very different time, very different cases, and now we're extending it to new cases, and I think it doesn't give us a lot of guidance how to decide it. So that was really an additional point.
Okay. No. I will catch up with what you said, just to make clear, because I know like a lot of you are aware of Xella, but to catch up on what you say, it has been a discussion, of course, in doctrine, because the Xella judgment was the only judgment that we have on the regulation. but the court decided to analyze it from a different perspective, analyzing the internal market. That's why my analysis from the jurisprudential is still sticked to the internal market, but because, as you say, like it should be, and it's actually a point that I think that is still good, but still I understood what you say. I mean, like taking more like the current context and not strictly related to criteria that were established with the geopolitical world was different. But in this sense, in positive terms, I can claim just like Advocate General Xella when she said actually if this question was asked, so the expansion to FDI to target the EU target 10 years ago, she would say no, of course, because of principle of discrimination, but today she will say yes. And I mean, just to take for the target, the new regulation actually talks about, in Italian is impresa figlia, in English will be the EU target, so those are under screening right now. Plus, we do have the possibility to have greenfield, as you know. So I think somehow they're trying to consider this changing that we need. Thank you.
Thank you very much. So now any other questions or comments? Anyone from you who would like to add something? Well, I mean, if there's like no urgent questions, then we can also dive in our coffee break. And now I would say we'll meet back at 10:30. Yeah. All right.